2, item 5 and 6.
Item 5 and 6.
Your Lordships, here in item 5 and 6, Manoj, there's going to be a change in counsel. I'll be representing the petitioners. So, my lords, if this matter may come up after 4 weeks, and we may be granted an opportunity to file a wakalatnama.
You won't be appearing anymore.
My lords, I'll be appearing.
Oh, you will be appearing.
Yes.
Okay. 5 and 6. Okay. Learned Counsel, Mr. Such has made a submission that he will be appearing in the matters as counsel for the petitioner and has prayed for 4 weeks' time
My lords.
to file his power. So, accordingly, list after 4 weeks for here.
Obliged.
Yes.
May I seek your Lordship's indulgence in making mention of part 2, item 2? If the matter may be taken up next Thursday, my lord.
Next Thursday.
Next Thursday, yes.
Okay. On the prayer of the appellant, or you're for the amicus?
Amicus, my lord.
You're the amicus.
Yes, I am
Okay,
the amicus.
So as such, please the matter on Thursday, date 4th. Yes.
Much obliged.
With your Lordship,
Yes.
just I beg to mention item number 1 of hearing list, may be taken up in May month of October, my lord. I have taken process from the other side.
October.
Yes, the 8th of
Why?
9th of October, my lord.
Otherwise, this was fixed for today.
Yes, Lordship,
Actually.
I have to take some instruction from the client, Lordship.
Instructions.
Yes, Lordship.
Learned Counsel, Mr. Such and Such, appearing for the appellant, has prayed for listing the matter in the month of August, as he has to seek further instructions from his client. So the prayer is not objected to by the other side. Accordingly, list it in the month of October. Yes.
Can it be on 9th of October, Lordship?
9th.
Yes, Lordship.
Are you an outstation counsel?
Yes, yes, Lordship.
Okay, 9th September.
Obliged.
9 October or 9 September?
October, Lordship.
October. It's not a holiday.
It's a Thursday.
Okay, 9th, yes.
Obliged.
Daily list for admission, item 1.
Lords, I appear for the petitioner in this case.
Lordship, I'm for the sole respondent. And Lordship, I have received the affidavit in opposition from the respondents number 1 to 6 yesterday evening. Lordship, so now we are compiling and photocopying. Then I may be allowed to file that affidavit in opposition within 2 days, Your Lordship.
You want to file a reply?
Yes, yes. No, I have to file the affidavit in opposition, yes.
You are for?
For the respondent, I'm for the respondent number 1 to 7.
1 to
I
7.
have already filed the affidavit for the respondent number 7 on 8/5/2025.
Okay. So for 1 to 6, you want
1
to
to
file?
6, yes, Your Lordship.
Okay. Learned Counsel for the petitioner, Mr. Such and Such present. Stop. Learned Counsel, Mr. Such and Such appearing for respondent number 1 to 7 submits that he has already filed the affidavit in opposition for respondent number 7. However, he requires some more time to file the affidavit on behalf of respondents number 1 to 6. Accordingly, list the matter when after a week.
No, my lords. My lords, if we may, I may specifically seek your lordships for this matter to be fixed on 2nd of September, next week. My lords, because the amendments have already come in the act. And
Lordship, no objection. It may be fixed on 2nd of September. no
Okay.
problem.
2nd of September then, and before which
In the
date,
meantime, I'll be filing
in the
down.
meantime,
Yes.
the respondent 1 to 6 shall file the affidavit in opposition.
obliged.
Item 2.
Lordship, this is a matter which may require some time. If other items are taken up before this, I think it would be convenient for my colleagues.
Okay. Go after some time.
Item 3.
Yes.
May it please your Lordship, I am here for the applicants
Okay.
and the respondents. I think they have.
Your Lordship, I am appearing on behalf of my senior, Mr. Sanjay Kumar Medhi.
Okay. for the
Kindly
respondent.
repeat matter on 15th of September.
You're appearing for the respondent.
Ah,
Respondent.
Yes, Lordship.
Okay.
Yes.
Learned counsel for the petitioner is present. Learned counsel such and such, put the name. Okay. So, learned counsel MS such and such appearing on behalf of
Sanjay Kumar Medhi.
Sanjay Kumar Methi for the respondent, prays for some time. And when do you want it?
15th of September.
15th of
No
September
objection.
is okay.
No objection, my lord.
And has prayed for listing the matter on 15th of September. Prayer is allowed, list on 15th September as prayed for.
Obliged.
Item 4.
My lord, I'm for respondent number 1, 3, 6, 7, and 8. I'm seeking another 3 weeks' time for filing affidavit.
Okay.
I am appearing for respondent 2, 4, and 5, similar prayer.
2, 4, and 5. And you are for 1,
1, 3, 6, 7, and 8.
3, 6, 7, 8. Learned counsel for the petitioner, Mr. Such and such present. Learned Central Government Council, MS such and such prays for some time to file their affidavit in opposition on behalf of respondent number 1, 3, 6, 7, and 8. So a similar prayer is made by the Learned Council, MS such and such appearing for respondents 2, 4, and 5. Stop. Accordingly, how much time? 2 weeks.
3 weeks may be given.
Accordingly, list the matter after 3 weeks in order to enable the respondents to file their affidavit in oppositions. Yes.
Could I pray, if it is not inconvenient for the court matter, could it be fixed on 9th of October with the other matter?
9th of October.
9th of October.
9th of October.
Yeah.
Okay. Fix on 9th October.
Deeply.
For orders, item 5.
Lordship, in this matter, we have filed 2 IAs. One is for impletement and one is for modification of the interim order.
What is the other IA?
We are the intervener, Lordship. We are not a party in the main writ petition. But however, the the interim order dated 14
Which one are we taking up now? IA
Lordship,
157.
157, that is for impletement of the present applicants.
Okay. Okay, let's see the order.
The order is on page 18 of the application, Lordship. This is the 14/8/2025 is the order date, Lordship.
Should it not come up before the same court?
No, Your Lordship. It's not a review. Any.
Having regard to the provisions of the recruitment rules as well as the advertisement. Guwahati High Court rules.
Any court can take up the matter, Lordship. In other matter also, this kind of modification has been practiced by this honourable
It will
court.
amount to modification. Huh?
Yes, it's for modification of the order only. To the extent of the completement.
That it should be concerned only with it should concern only the respondents and the petitioners, isn't it?
No, this.
Or
if
you were not impleted as respondents,
yes,
but this order is affecting you.
Yes, yes. So the impletement application, Lordship, at this stage can be allowed.
Yes, of course, impletement can be allowed.
And the modification also can be taken up some other day also, Lordship.
Okay, you just go through, okay, once regarding the modification, whether any court can do it. Then first, let's allow the impletement. have no objection, Mr. Malhotra? Yeah. I'm sorry.
157.
Yes, 157 is the implement application.
157 is the implement.
Implement, we have no objection, but
Yes.
if it's modification, then I think it can affect the seniority of the private respondents. So,
No, we won't take up the modification today. We'll,
sometimes we-
yeah, we'll list it for another day. We'll just issue notice there. So now, first, this is 157. This application has been filed by the present applicants, who are you? You are
We are in serial number 9 and serial number 12 of the impugn notification dated 30th July 2025. I have annexed it in my application, Lordship, that is on page 20. 20 ka ang pangay, so
yes,
on
yes.
22.
In the notification of 37, right?
Yes,
In the impugn
37,
notification of 37, 2025, you are at serial number
9 and serial number 12.
9 and 12. That by the applicants who are at serial number 9 and 10
9 and 12.
12th.
serial number 9 and 12 in the impugn notification number technical /1/2024-MPSC con in brackets dated 37/2025. Stop. It is the submission of the learned counsel for the applicants MS such and such that the present applicants are not impleted as party in the writ petition number 94 of 2025. Stop. However, by the impugned, by the order dated 14/8/2025 passed by this court in WPC 94 of 2025, the court had directed that no appointment shall be made pursuant to the impugned notification dated 30/7/25 issued by MPSC until further orders. Stop. And by this order, the applicants herein have been affected as their appointment orders have also been held up, isn't it? As their appointment orders have also been held up, and accordingly, it is prayed that they may be allowed to intervene in the writ petition number 94 of 2025. Stop. The learned counsel for the petitioner in WPC 94 of 2025, Mr. E.R. Malhotra, and the learned additional AG, MS Linda such and such, and also MS for the MPSC, such and such for the MPSC are present and have no objection to the said prayer. Stop. Accordingly, the application is allowed, and the applicants are allowed to file their. So now the cause title will be amended, or what will happen now?
I think their prayers should be implemented as respondents 18 and 19.
18 and 19.
Okay. So the applicants may be allowed to be implemented as respondent number 18 and 19 in the writ petition 94 of 2025. And the petitioners shall, you have to amend the cause title then.
Your Worship, in that case,
And put it in. And
the registry can just add them.
Add them.
Yes, the cause title can be.
The registry is directed to amend the cause title and add the names of the present applicants as respondent number 18 and 19. respectively. Yes. Yeah, just by hand. Just enter in the cost title. No. That's why I'm telling them to file the amended cost title. No, actually, yes. I believe there's a notification that it cannot be entered. So just one page cost title amendment, no problem. Yeah, not the registry, huh?
In the main writ petition,
petitioner.
I think.
In the main writ petition.
In view of the order passed in CM application today.
Yes. That order will be passed. Yes. So the appellant, the petitioner will do it. Okay, not the registry. Then in the main petition, then this IA. No, wait. We'll take up the IA first. IA 50. IA 150. You just say. The applicants herein, that same, okay, who are serial 9 and 12, they don't have prayed for modification. Your prayer is at
Your prayer
page,
portion is at page number 12.
prayer for modification of the interim order 14/8/2025 passed in WPC 94 of 2025 to the extent that the order dated 14/8/2025 will not be a bar to proceed with the appointment of the applicants, that is serial number 9 and 12 in the impugned notification memo number technical / such and such dated 30/7/2025 to the post of surveyor. Stop. Para. Issue notice to the petitioner and the respondents. No, just issue notice to the respondents. You have received copies, otherwise.
Yes.
As the respondents have already entered appearance in WPC 94 of 2025, no formal notice is called for. List the matter after 2 weeks. After 2 weeks. Okay. Then in the main petition, you say, in view of the order passed in IA 157, the petitioner is directed to file the amended cost title, pleading the applicants as serial number 18 and 19, as respondent number 18 and 19. Stop. Yes. This one also same thing after 2 weeks.
Item 2 for admission.
Yes.
Lordship, this is a matter relating to the non-compliance of the specific provision of the contract between the contractor and the employer. Contractor, who is an employee, had executed in his name 11 works under PMGS way. And all those works, except for 3 works, which I'll be mentioning, were completed. And in the meantime, the petitioner's late father, who is the contractor, had died. And on his death, there's a provision under the GCC, that is General Conditions of the Contract, which is part of the contract agreement between the employer and the contractor, that on the death of the contractor, the contract shall be closed. And here, if I take a lordship to page 76, of the writ petition, there's a provision under para 55.2, clause 55.2. 55 is pertaining to release from performance.
55.
Has a
Yes,
got it?
yes,
Page
55.
76.
Point 2.
Yes. May I read from point 1?
Okay. Yes.
If the contract is frustrated by the outbreak of war or by any other event entirely outside the control of the employer or the contractor, the engineer shall certify that the contract has been frustrated. The contractor shall make the site safe and stop work as quickly as possible after receiving the certificate, and shall be paid for all work carried out before receiving it and for any work carried out afterwards to which a commitment was made. 55.2. Death or permanent invalidity of the contractor. The contractor shall indicate his nominee for the contract at the time of signing of agreement. If a contractor dies during the currency of the contract or becomes permanently incapacitated and his or her nominee are not willing to complete the contract shall be closed without levying any damages or compensation as provided for in clauses 44 and 53 of GCC. I'll take a lordship to the facts of the case at Annexure 1 at page 26. The lordship will see that the contractor, Mr. Biakliana, had died on 3/7/2022.
Okay.
At page 26, the lordship.
Page 26. Yes.
And as per the relevant clause, that is clause 55.2 of GCC, on his death, the contract is to be closed. The contract shall be closed without levying any damages or compensation as provided for in clauses 44 and 53 of GCC. And if I take a lordship to the relevant clause, that is 44,
44.
which is at page 70. 44 is regarding
Yes.
liquidated damages.
Liquidated damages.
Here at 44.1, in the event of failure on the part of the contractor to achieve timely completion of the project, including any extension of time granted under clause 27, he shall, without prejudice to any other right or remedy available under the law to the employer on account of such breach, pay as agreed liquidated damages to the employer and not by way of penalty in a sum calculated at the rate per week or part thereof as stated in the contract data for the period that the completion date is later than the intended completion date. Liquidated damages at same rate shall be withheld if the contractor fails to achieve the milestones prescribed in the contract data. However, in case the contractor achieved the next milestone, the amount of the liquidated damages already withheld shall be restored to the contractor by adjustment in the payment certificate. Both the parties expressly agree that the total amount of liquidated damages shall not exceed 10% of initial contract price and that the liquidated damages payable by the contractor are mutually agreed, genuine, pre-estimated loss and without any proof of actual damage likely to be suffered and incurred by the employer, and the employer is entitled to receive the same and are not by way of a penalty. So here, this 44 is all pertaining to liquidated damages on the default on the part of the contractor. The liquidated damages can be charged upon the contractor. And if I take lordship to page para 53, that is clause 53, which has been cited in 55.2. 53 at page 75, Your Lordship.
Okay, payment upon termination.
Payment upon termination. 53.1. If the contract is terminated because of a fundamental breach of contract by the contractor, the engineer shall issue a certificate for the value of the work done, less liquidated damages, less advance payments received up to the date of the issue of certificate, and less the percentage to apply to the value of the work not completed, as indicated in the contract data. If the total amount due to the employer exceeds any payment due to the contractor, the difference shall be recovered from the security deposit and performance security. If any amount is still left unrecovered, it will be a debt payable to the employer from state PMGSY works and other state government works, including state public sector works executed by the contractor. Your Lordship, this has clearly mentioned and specified the manner in which the payment can be extracted from the contractor for his failure to execute the contract in a proper manner. So, if on that event, when there is a fundamental breach of contract caused upon the contract works by the contractor, then such payments can be recovered. And here it is mentioned in the middle of the paragraph, if the total amount due to the employer exceeds any payment due to the contractor, the difference shall be recovered from the security deposit and performance security. If any amount is still left unrecovered, it will be a debt payable to the employer from state PMGSY works and any other state government works, including state public sector works, executed by the contractor. And 53.1, subclause 2, if the contract is terminated because of a fundamental breach of contract by the contractor due to non-compliance of the requirements of clause 32 of GCC regarding defect liability period and routine maintenance of roads for 5 years, the engineer will assess the cost of having the defect corrected. If the total amount due to the employer exceeds any payment due to the contractor, difference shall be recovered from the security deposit and performance security. If any amount is still left unrecovered, it will be recovered from any dues payable to the contractor from state PMGSY works, any other state government works, including state public sector works, executed by the contractor. If any amount still remains unrecovered, it shall be recovered as area of land revenue. So in any way, if the contractor has caused a default and there is a fundamental breach of the contract, then the employer is at liberty to recover all such amounts from the contractor. And even if there is a deficiency in the amount which is connected to that particular work, then the employer can still jump over to the other contract works. Yes.
Other works executed by that same contractor.
Yes, executed by the same contractor. So these are the provisions under which these recoveries can be made from the contractor. But this 55.2 is dealing with the death of the contractor. When he dies, on his death, the contract shall be closed without levying any damages or compensation as provided for in clauses 44 and 53 of GCC. So it has to be simply closed. And on its closure, what is intended by this provision of the GCC is that all the security deposits and unbalanced bid security deposits and other deposits created at the time of execution of the work by the contractor will have to be released to the nominee or to the a person who is the legal heir of the
Legal heir.
deceased.
Hmm.
So,
So
that is
these clauses which you had been reading out, you're trying to say that these are only when there is a breach of contract.
yes, only when there's a breach of contract, this 44 and 53 are can be invoked by the employer, but under the given condition, under the given circumstance, when the contract cannot be executed or completed because of the death of the contractor, and without levying any damages or any penalty as provided under these clauses 44 and 53, the contract has to be closed. And in this connection, Your Lordship, the petitioner had executed 11 contract works, which are mentioned which I have mentioned under para 2A at page 3. At page 3, I'll just take a lordship to para A.
Yes.
Just below 2, there is A. During the period from 2013 to 20, 11 contract works for construction of roads on the PMJ's way were allotted by the respondents in the name of Sri Biakliana, the petitioner's late father, referred to as the contractor. The said 11 works are shown in a table below. And the name of the works are at column number 2. Column number 3 is the agreement, the amount, and the remarks as to whether it is completed or it is still incomplete. So 11 works have been mentioned here with the amount of the contract, the agreement amount. And at para C, at page 6, Your Lordship, page 6,
Para C.
para C, I have shown that under clause 39(1) of GCC, it has also been provided that payment shall be adjusted for deductions in respect of advance payments, security deposits, other recoveries in terms of the contract and taxes at source as applicable under the law, and that the employer shall pay the contractor the amounts the engineer has certified within 15 days of the date of each certificate. The petitioner had prepared in a tabular form all the amounts deposited, including those RA bill or BA, to be released to the petitioner on the date of the contractor, as can be seen herein below. So here, Your Lordship, if I take Lordship to serial number 1, construction of Jokna Suri to Karlui Road, package number so and so, performance security that has been deposited is 23 lakhs, and unbalanced bid security is 16 lakhs. This unbalanced bid security comes only when the bid of the petitioner, the bid of the contractor is extremely low. So it is said to be an unbalanced bid. And for the purpose of security, that even with that amount, he is able to complete the work. For the purpose of security, this unbalanced bid security was demanded, and this 16 lakhs was put as security, unbalanced bid security. And there is security deposit, 57.4, and at the same time, the next column is regarding mobilization advance, machinery advance and all that. And on execution of the work, and even at the time of physical completion, the RA bill is still pending. It was still pending at that point of time. That was 86 lakhs 39,000. So the total payment pending to be paid to the contractor at the time of his death was 1,82,43,879. And the work was physically completed. And Lordship, I'll not go into all the details of all those works. And at the end, at page 8, all those deposits which were to be reimbursed to the petitioner because of the death of the contractor has been shown. The total amount has been shown as 16 crore. Only 6 will be appearing because of the mistake. 16 crore,
16 crore, 34
lakhs, 18,670. From the above table, it can be seen that the respondents had illegally retained a sum of rupees 16 crore, 34 lakhs, 18,670, which were to be released to the petitioner immediately on the death of his father, the contractor, on 3/7/2022, as per clause 55.2 GCC. This is what was due upon the respondents. And before filing the instant writ petition, Your Lordship, the petitioner had submitted his claim for closure of all the contracts because of the death of his father, the contractor.
No, you had approached this court earlier also.
Yes, he approached this court earlier by filing WPC number 2 of 2024.
Then what did the court say?
The court had passed an order
Okay, let's continue at 2. It's time.
All right.
Let's continue at 2.
were issued and payments made on the basis of measurements strictly conducted by the employer or his representatives, duly approved by the respondents. In fact, all such measurements were entered in the measurement book and uploaded in the OMAS, that is Online Management, Monitoring and Accounting System, operated by NRRDA, that is National Rural Roads Development Agency, now known as NRIDA, National Rural Infrastructure Development Agency, under the Ministry of Rural Development Department, Government of India. And the same can also be seen in the monthly progress report of July 2022. The petitioner had stated that the work, that is construction and maintenance of Pura to Vahai Road, was physically taken up and executed by Sri Malsom Tluanga, nominee for that particular work, appointed by the contractor. In fact, Malsom Tluanga had made a notarized declaration under his own signature in which he had stated, among other things, that he was solely accountable, liable and responsible for the said work in terms of execution as required by specification and nodal department maintenance of road for a period of 5 years. He had also agreed and submitted his willingness to continue execution of the said work on the date of the contractor. Lordship, the application for continuation we have enclosed here, submitted by Mr. Malsom Tluanga. And Malsom Tluanga was asked to submit his credentials, such as documents such as bank certificate, financial turnover, machineries and engineer certificates to show his credentials or competence to execute the work as per instruction of respondent number 4. In this connection, if I take Your Lordship to the earlier provision of law, which I have read out at page 76. Page 76, clause 55.2. Death or permanent
Yes,
invalidity of
death.
the contractor. The contractor shall indicate his nominee for the contract at the time of signing an agreement. If a contractor dies during the currency of the contract or becomes permanently incapacitated, his or her nominee are not willing to complete the contract shall be closed without levying any damages compensation as provided for. Here, the fact is that the nominee of the contractor, he had submitted his willingness to complete the work, but that was not accepted by the respondents. This is what we have stated here in this para H. He has submitted the required documents. However, for reasons best known to the respondents, no further action was taken for appointment of Malson Tuanga to continue execution of the said works. If I take a lordship to the monthly progress report made by the department itself, which is at page 79, a lordship, Annex 4.
Provisional monthly progress.
Provisional monthly progress report for the month of July 2022. Name of the work, construction of Pura to Vahai Road. Name of contractor, Mr. Biagliana. Scheme, PMGSY. Sanction amount is 1468.31 lakh. And here, because of certain deviations, it has come to 15 crore 63 lakh, 6392 lakh, 1,563.92 lakh. So here, a lordship will see the unit under column 3. These are and under column 4 is the quantity of work to be done, and cost in lakhs. Target during the month, physical, financial. Achievement for the month. Target for the next month, overall cumulative achievement. So, physical achievement in respect of sub-base course, 17 kilometers. And base course, 17 kilometers. And wearing course, 15.6 kilometers. Retaining wall, 213. That is, the whole thing was done. And line, side drain, under side drain, serial number 5, 1642. So, the physical achievement is commensurate with that of the financial achievement, overall cumulative achievement, financial and physical. The total amount that was already paid was 1409.460 lakh. This is what has been uploaded in the OMAS. And after receiving all the documents and the affidavit of the parties, the matter was heard and finally decided by this Honorable Court. On 16/7/2024.
Let's see the order.
Yes. It's at page 84, Your Lordship. Page 84 is the order passed by this Honorable Court in the earlier round of writ petition.
WP 2 of 24.
WPC 2 of 2024. It is not very long, Your Lordship. It will help the Lordship to understand the basic facts
Yes.
if I read the
Yes,
relevant
please read.
portions.
Please read.
May I read from Para 2?
Para 2.
By filing this writ petition at page 85, under 226 of the Constitution, petitioner prays for a direction to the respondent authorities to release the performance security deposits, unbalanced bid security deposits, as well as pending RA bills or BA bills to him. It is the case of the petitioner that he is the son of Biakliana, who is the contractor, and who was awarded as many as 11 contract works for construction of roads under PMGS way by the respondents. Although Sri Biakliana managed to complete most of the allotted works physically, but however, before he could complete the entire work, he expired on 3/7/2022. The petitioner, as the son and nominee of the late contractor, expressed his unwillingness to continue with the remaining balance work by submitting his representation before the competent authority on different dates, except for the work in respect of construction of Pura to Vahai Road. That is package number so-and-so 912, group number 133. For the said work, the petitioner was not the nominee and appointed nominee, although expressed his willingness to continue with the work. No positive response was given by the respondent authorities, and therefore the petitioner had to request the termination, had to request for termination of the contract work in respect of the said package. For the sake of convenience, the name of the work, the agreement, the agreed amount, and the relevant remarks as provided by the petitioner in writ petition is abstracted hereunder. You can just skip this. Mr. Sila Ramzava has drawn the attention of this court to the general conditions of contract, more particularly clause 55.2. The same is abstracted hereunder for ready perusal. We have read it, Lordship.
Yes.
Para 7. Referring to the above abstract, the Learned Senior Counsel submits that the contractor is required to indicate his nominee for the contract at the time of signing the agreement, and if he expires during the currency of the contract or becomes permanently incapacitated, and further, if his nominee is not willing to complete the contract is to be closed without levying any damages or compensation as provided for in clauses 44 and 53 of GCC. The Learned Senior Counsel submits that in terms of the said provision, petitioner had communicated to the respondent authority concerned, expressing his unwillingness to continue with the remaining work as the nominee of the contractor, but despite the same, respondent authorities have failed to take any positive step for closure of the contract for refunding of the amount due to the late contractor to the petitioner. The Learned Senior Counsel also submits that the petitioner has also come to learn that the respondent authorities have floated tender inviting application for execution of the balance work in respect of construction of New Otlang to Chakang Road, package number so-and-so, and Nalkon to Rulkwal, 2 packages. The Learned Senior Counsel submits that during the pendency of the writ petition, the Finance Controller, Mizoram Rural Roads Development Agency, apparently on the direction of the respondents number 1, 2, and 4, had written to the branch manager of HDFC Bank, Longtlai branch, Yes Bank, Aizawl branch, and State Bank of India, Mission Veng branch, Aizawl, for release of fixed deposits. The amount includes both performance security deposit and unbalanced bid deposit amount to rupees 3.66 crores. The learned senior counsel submits that the release of the aforesaid amount during the pendency of the writ petition has gravely prejudiced the petitioner, inasmuch as there are outstanding dues which is yet to be released to the petitioner, which comes to a sum of rupees 14 crore 68 lakh 97 and 699. Mr. Samuel Vanalshia Sangte, learned additional AG, submits that since the contract was awarded to the contractor in terms of the contract agreement governed by the general conditions of the standard bidding documents for PMJSY, whatever amount that may be due to the petitioner can very well be examined by the respondent authorities in terms of the relevant provisions. Upon considering the submissions made by learned counsels or for rival parties and upon perusal of materials available in record, and importantly, having regard to the provisions of the standard bidding document, particularly clause 55.2 of the GCC, Court is of the view that instead of going into the nitty-gritty of the issue raised, it would be better for the respondent authorities concerned to examine the claim of the petitioner and to take a decision within a time frame. In view of the above, the petitioner shall submit his claim before the respondent number 4, along with all details and supporting documents within the period of 2 weeks from today. And the respondent number 4, upon receipt of the same, shall undertake necessary verification and examination of the claim in terms of the agreement that was made between the parties. And as per the standard bidding document and the GCC, more particularly clause 55.2 of GCC, as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of the claim made by the petitioner. Upon such examination and verification, the amount due that has been worked out should be paid to the petitioner within the period of 2 months from the date of completion of the said verification. It is also further provided herein that if the petitioner is still aggrieved with the amount worked out by the respondent authorities, he will be at liberty to seek such remedy as may be available to him in law. So, pursuant to that, Your Lordship, the petitioner had submitted his claim as per Annexure 9 at page 92. And the specific claims made in connection with all the 11 works have been shown in a tabular form. And now,
after this, was there any reply? Was there any reply by the
there
respondents?
was no reply. There was no response in the form of payment. And as a result, after long waiting, the petitioner had submitted another representation demanding immediate payment at page 95. Lordship.
Page Annexure 10.
Annexure 10. So this was submitted on 25/11/2024, and wherein he had stated that because in view of the above, the inaction on your part cannot but be construed as deliberate violation of the specific direction of the Honorable High Court, as stated above, amounting to contempt of the court. Accordingly, I would have no other option but to approach the Honorable Court if no payment as contemplated and claimed by me for release of the said amount of rupees so and so is made to me within a period of 10 days. And in the meantime, Your Lordship, on 5th October 2023, the issue of notice to proceed with work in respect of the said works, the unfinished works, have been issued to Srimati Parmoy and Lusai Engineers, because the petitioner was not willing to continue with the said 3 works, other than those which have been completed. The petitioner would have no grievance, except for the fact that before closing the contract, as provided under 55, clause 55.2, they had issued the work order in respect of those 2 works.
To other persons.
Yes, to other persons. And in fact, they had also issued the NIT in respect of the construction and maintenance of Pura to Vahai Road. That is the third work, which is at serial number 6 in the list, which was provided by the petitioner.
So for this also NIT is issued.
Yes, NIT was also issued before closing the contract. Your Lordship, this was what happened in between, before filing of this writ petition and after filing of the earlier writ petition. And during the course of the proceeding, the petitioner was given as stated in para 6 at page 17. Para 6 at page 17, Your Lordship. Well, the petitioner was contemplating filing of a contempt petition due to specific and deliberate violation of the direction of this Honorable Court. He came to know through his mobile phone by way of SMS alert that the following amounts were credited into the bank account of at SBI Mission Bank branch in the name of Biaklian and Sons, operated by the petitioner. So all these amounts were credited on 2/12/2024, and the branch code is the same, and the amount credited, the total had come to 7,40,79,214. So this was without making any statement of fact as to whether these amounts were credited in the account of the petitioner or Biaklian and Sons, operated by the petitioner, in respect of any particular work. Nothing was mentioned, nothing was indicated at the time of crediting. And while the amount claimed by the petitioner in his letter, that is submission of claim, dated 24/7/2024, without interest was 14 crore 19 lakhs 94,114, and the total amount claimed by him with interest at the rate of 12.5% for 2 years, with effect from the date of the contractor, that is on 3/7/2022, was rupees 17 crore 74 lakh 42,643. The amount that has been released to him was only 41.74%, and no information was given to him as to how much was released in connection with each of the 11 works specified by the petitioner in his claim. There is a balance amount of rupees 10 crore 33 lakhs 63,429, which includes interest at the rate of 12.5% for 2 years, yet to be released to the petitioner at this stage. And none of the contract in respect of the said 11 works has been closed as required under clause 55.2 of GCC. So, Lordship, this
okay,
is...
so according to you, this balance amount is still there, 10 crore, 33 lakhs, etc., such and such.
Yes, yes.
Okay, so that means, what are the respondents saying in their affidavit?
The respondents have taken the stand by filing the affidavit in opposition. It is a lengthy reply, lengthy affidavit. What they have stated in sum and substance is that after making deduction of the excess payment paid in advance to the petitioner in respect of the work that is Pura to Vahai.
But there is only one in respect of
Yeah,
one
only
work.
in respect of only one. In that, they said there are a lot of excess payment. But according to them, only after deducting all those excess payment we are releasing that 7 crore something. And there is no more amount to be released to the petitioner. This is what they have stated in some substance. If I take a lordship to the
Learned Counsel, I think there are so many disputed things here. They are disputing the amount also. I think the best remedy would be the civil court, isn't it? How this court cannot adduce evidence with regard to all these disputed amounts.
that appears quite to be true.
Yes.
But lordship, the only thing is that if they comply with their own condition, terms and condition of the GCC.
No,
what they have said,
closing the contract and all that, okay, fine. As per the GCC, that has to be done. But regarding the amount which is due to you, since there is dispute, so regarding the amount, this court cannot...
there is no dispute, lordship. I'll take a lordship to the statement.
No, there appears to be dispute. You are claiming something, they are saying you are entitled to something else.
What they have stated in my affidavit in opposition reply. In my affidavit in reply, at page 15. At page 15, para 12. The matter has boiled down to very simple matter. And here what they have stated in para 11 of the affidavit in opposition, if I take a lordship to para 11 of
Yes, para 11.
para 11. Para 11,
Yes.
lordship.
Affidavit in opposition.
Yes, affidavit in opposition. That with regard to the statements made in paragraph number 4 of the writ petition, I say that the petitioner submitted his claim, including a demand for interest at rate of 12.5% per annum. Upon scrutiny, the claims were verified and accepted. The claims were verified and accepted, except for the claim of 12.5% interest. The interest claim was not accepted in view of the fact that dispute had arisen concerning the execution of the work titled Construction and Maintenance of Pura to Vahai Road, particularly with regard to excess payment and fundamental breach of contract by the contractor. So what they have stated is that they have accepted, they have made scrutiny of the claims made by the petitioner, and they have verified and accepted the claim of the petitioner, except for the claim of 12.5% interest. Now, just leave aside that portion of the claim of 12.5%. They have said that, yes, you have made the right claim. The amount which you have projected in the claim is this much, we have understood. But so far as the interest at the rate of 12.5% is concerned, we are not in a position to accept that. This is what they said. And in a reply to the affidavit of the respondents, we have stated at para 12, Lordship, para 12
Yes,
of
para
the
12
affidavit.
of the reply.
Yes, reply. That with regard to the statement made in para 11 of the affidavit in opposition, I beg to state and reiterate what I have stated in the corresponding para 4 of the writ petition. Further, in view of the statement of the respondents that upon scrutiny, the claims were verified and accepted, except for the claim of 12.5% interest. The claim of the petitioner in his representation for a sum of rupees 14 crore 19 lakh 54,114 was without interest at the rate of 12.5% per annum for 2 years, and the same was accepted by the respondents. However, out of the said accepted amount of rupees 14 crore in oath, only 7 crore 40 lakh 79,214 was released to the petitioner after making deduction of the alleged excess payment made to the contractor in connection with the work for construction of Pura to Vahai Road. Now what is left to be considered by the Honourable Court can be summarized as below. A. Whether there was at all an excess payment made to the contractor in respect of the said work, that is construction of Pura, Vahai Road, if so under what provision of the GCC. So the claim is that there is an excess payment. There is an excess payment which we have denied. And now, whether there was at all an excess payment to the contractor in respect of the said work in the construction of Pura Vahai Road, if so, under what provision of GCC? B. Whether the petitioner would be entitled to payment of the amount claimed by him, that is 14 crore 19 lakh 54,114, with interest at the rate of 12.5% per annum for a period of 2 years, starting from the date of death of the contractor, that is 3/7/2022, till filing of his representation dated 24/7/2024, as directed by this Honourable Court in WPC number 2 of 2024, by its order dated so and so. Lordship, if I'm allowed to read on. So far as the claim of the respondents regarding excess payment made by the contractor is not supported by any reliable or authenticated document, the only officially acceptable document in that regard, as stated earlier, is the measurements in respect of RA bills 1 to 9, recorded in all the computerized measurement books as provided under clause 38.1c of the GCC. Lordship, if I'm allowed to go back to the GCC, that 38.1. What is provided under 38.1 is payment.
Page?
Yeah, page 68.
Mm, 38.1, yes. The payment to the
yes,
contractor.
Payment certificates. Payment to the contractor will be as follows for construction of work. And 38.1c, I have quoted C. The value of work executed shall be determined based on measurements by the engineer. So, for making payment of any amount, the work executed by the contractor needs to be measured. And that measurement is not to be done by the contractor, it is to be done by the employer, the engineer. And that measurement is recorded in the measurement book. And whatever that was recorded is uploaded in the OMAS. That is what we had earlier stated.
Yeah, that online
yes,
system.
online management. And the value of work executed shall be determined based on measurement by the engineer. So what I have stated is that there is no excess payment. It is on the basis of the RA bills, running account bills from 1 to 9 were made on the basis of measurement taken by the engineer in respect of the work executed and completed by the contractor. So here, pursuant to payment of the said RA bills, the respondent number 4 had also prepared the monthly progress report for the month of July 2022 as shown in Annexure 4 of the writ petition, which I had already read out, Your Lordship. And the same has been uploaded to OMAS as stated earlier. It is humbly submitted that if the respondents have any version other than what they had uploaded in the OMAS, they are at liberty to replace the same by another version. However, till date, data of the MPR, this is monthly progress report, for the month of July as stated herein, said to be in the OMAS as the only reliable official information or document pertaining to the said work, that is construction of Pura to Vahai Road, in which it was clearly stated that overall cumulative physical achievement is shown under column 12 and the overall cumulative financial achievement is under column 13. And out of the total cost of rupees 15,563.92 lakh, 14,009.46 lakh had already been paid to the contractor, which is 90.12% of the total cost. In this connection, it may be pointed out that, as stated by the Union Minister of State for Rural Development in response to a query made in the Rajya Sabha, that the OMAS as on today has become a robust instrument for monitoring various aspects of PMJ's way. Lordship, this OMAS has been taken as the only reliable base for getting information in respect of PMJ's way. And that in terms of transparency and level of data, OMAS is having all purposes with respect to monitoring, and that PMGS way is committed to establish transparency and accountability in the scheme or process. Through the revamping of MIS portals, planning at the block panchayat, geotagging of roads, reporting at the of the scheme on a monthly basis, and timely evaluation. In fact, we have enclosed the statement of the Minister concerned at Annexure A5. Lordship, here, why we have gone to that far is because the respondents are operating the OMAS. They are feeding the OMAS with all the information, and it is transparent. It can be seen from the central government also, because it is the robust instrument for monitoring various aspects of PMJ's way. It is the work under contention is under PMJ's way. And now they had uploaded, and though we are the contractor and our work is concerned, but we are not allowed to see. But what they have furnished as the information in respect of the month of July 2022, we have enclosed as Annexure 4.
The one which you were showing
Yes,
earlier.
yes. So what I have stated further is that other than what they have stated in the OMAS, which they have uploaded, if they have any other information, let them satisfy the Honorable Court. And if Lordship, they are disputing what they have stated and what we have stated here, Lordship may also call for the records of the OMAS. This is the only transparent and reliable information.
Are we
So
to
far
understand, Learned Counsel, are we to understand that now you are not disputing any of the other amounts which are deposited in respect of other works?
Other
now
works,
you're
no.
only disputing this Pura Vahai Road.
Yes.
Only this one.
Only this one. I mean, they are not disputing. We are making a claim. They are not disputing. They have said that
The amounts deposited
yes.
in paragraph 6, which you have said, that table which has been tabulated by you.
Yes.
This page, para 6. So these amounts also you are not disputing.
We are not disputing.
Only this Pura Vahai Road.
Pura Vahai Road, we are
this you are
disputing in
saying?
the sense that what they have stated in respect of Pura Vahai Road is that you have taken excess payment. This is what they said. You have not executed most of the work, not only you have executed only to the extent of 50%, whereas in the monthly reports, in the month of July 2022, it has been shown that physical achievement is of 90%, and similarly financial achievement is also 90%. So, but at the same time, they said on the basis of verification of the work, you have not performed, you have not done such and such work. This is the stand of the respondents. So, based on that, they said that you have taken excess payment in respect of the work. So, we have to make recovery from other works. I mean, the deposits which have met in connection with the other works. Yes. So, what I have said is that the measurement which was taken by the engineers in connection with that Pura to Vahai road is the only valid and accepted document, because it is computerized and it is a measurement which was conducted by the respondents themselves.
So as per Annexure 4, your
Yes.
submission is that, where do we find that 90%? In Annexure 4? Physical progress, you're saying, no?
Yes. The percentage is not given here in the report itself, but the financial achievement, overall cumulative achievement, physical, is under column 12, Your Lordship.
Column 3.
Yes, column 12.
Column 12. Okay.
This is the physical achievement. And the financial achievement is also given as 1409.460 lakh.
Okay, so your prayer is why respondents should not be directed to take immediate by closing all the said 11 contract works and to release the amounts pending in connection with all such as mentioned below, adjusting the amount already released to him.
What I have stated in connection with that provisional monthly report, progress report, is under para G. Para G. This is the stand of the respondents.
Yes.
The stand of the respondents.
Yes.
May I read from
they said that yes, already 90.12% was paid. That's what they said.
Yes, 90.12% from the total contract price that was paid. According to them, at the same time, the physical achievement, physically completed, is only 50.21%.
Okay.
This is the claim of the respondents.
Yes,
The main stand. The main stand projected against the petitioner. And what we had stated in para H is that this is on the basis of the RA bills 1 to 9, and the RA bills were based upon the measurements taken by the contractor, by the engineers in the presence of the contractor. And payments were also made in respect of all the RA bills 1 to 9, 1 to 13.
Okay, yes, anything else?
Your Lordship, so when they said that we have accepted the claim of the petitioner in respect of in connection with the statement at para 11, when they said upon scrutiny the claims were verified and accepted except for the claim of 12.5% interest. Now the only dispute is as to whether the respondents would be made liable to pay interest at the rate of 12.5% interest. And here we have stated that we also had taken loan. The contractor had taken loan, and that CC loan is at the rate of 12.5%. And I have enclosed here the CC loan account of the petitioner, the petitioner's late father, at page 34 of the reply affidavit. At page 34, Lordship, next A6. Lordship will see
Yes, A6.
Interest rate per annum, percent per annum, 12.5%. This is the account of Mr. Biokliana. Account description, EB, MSME, CC, usual credit dispense. There is no mention of the drawing power. No, it has no limit. And whatever loan that was taken on the CC account, that needs to be repaid with interest at the rate of 12.5%. So here, this is the money with which the contractor had executed the work. And when payment was not released on his date, and when it was retained for a number of years now, he died in on 3/7/2022. Now we are in 25. 22, 3, 4, 5. 3 years.
3 years.
More than 3 years now. And in that, we had made a claim for payment of interest for 2 years. From the date of death till making of the representation, submitting of the claim as directed by the Honorable Court. So the interest had come to about 3 crore. So the total had come to about 17 crore. And now what they had paid is 7 crore something. The amount that is still pending is 10 crore something. And we also made a claim in this writ petition that even that amount to be paid is to be paid with interest at the rate of 12.5%. This specific prayer has been made by the petitioner in this writ petition also. Lordship, this being the case, there is no reason for the respondents to make deduction of any amount from the security and other deposits which were to be released by the respondents to the contractor, on the date of the contractor to the petitioner, as provided under clause 55.2 of the GCC, which binds both the contractor and the employer. They cannot say that you have to comply with all the provisions, but we are not, we are at liberty to pull this provision in this and that manner as we desire. Now that a reading of this affidavit in opposition of the respondents has indicated that they have made deduction. They have made deduction. If I take a lordship to page 24 of the affidavit in opposition, it appears that they are relying upon the clause 53.1 of the general conditions of the contract for the purpose of deduction. According to them, at page 24, Lordship,
Yes.
may I read the relevant portion?
Yes. The second last para.
Second last para, yes, even starting from middle of the page. Excess payment as per spot verification on November 2022 by the next 5, that is rupees 762.44 lakh. Recovery made after assessment of balance work held on March 2024 by Executive Engineer PWD Saiha, 90 lakh. And excess payment to be recovered from contractor, that is 671.90 lakh. Therefore, reiterating clause 53.1, subclause 1 of the GCC, it is explicitly provided that if any amount is still left unrecovered, it will be a debt payable to the employer from the state PMGSY works, any other state government works, including state public works executed by the contractor. So based on this, they have taken the recourse that we have made adjustment of the excess payment. Excess payment, according to them, they have made payment in excess of the work executed by the contractor. But whatever measurement they had taken is in respect of the work. They had taken the measurement themselves and they had made the record in the measurement book, and that is the only basis for making payment. Now, after the date of the petitioner, they said, you have caused fundamental breach of the contract, and as a result, you are punishable, and we are going to levy such penalty as provided under 53.1 and even 44, which according to clause 55.2, it has been clearly stated that without levying any damages under clauses 53 and 44 of the GCC. So in that view of the matter, they have contradicted themselves right from the start, Your Lordship. At the time of making the tender, issuing the tender, NIT, they had floated the tender with all the terms and conditions, and we are bound by such terms and conditions. And they said they are not bound by the terms and conditions. Now, if that is the stand of the respondents, Your Lordship, if they are allowed to blow hot and cold at the same time, that will not be for the ends of justice, it will not be permissible. In this connection, Lordship, may I make reliance on the decision made by the Apex Court in 1995. (1996) and my Lordship, 1995, 1 SCC,
274.
page 274, para 11 and 12, my Lordship. May I read a lot?
Yes.
Para 11. The doctrine of promissory estoppel or equitable estoppel is well established in the administrative law of the country. To put it simply, the doctrine represents a principle evolved by equity to avoid injustice. The basis of the doctrine is that where any party has by his word or conduct made to the other party an unequivocal promise or representation by word or conduct, which is intended to create legal relations or affect a legal relationship to arise in the future, knowing as well as intending that the representation, assurance or promise would be acted upon by the other party to whom it has been made, and has in fact been so acted upon by the other party. The promise, assurance or representation should be binding on the party making it, and that party should not be permitted to go back upon it if it would be inequitable to allow him to do so, having regard to the dealings which have taken place or are intended to take place between the parties. Lordship, by their very action, by making that particular clause available for the purpose of implementation of the contract, they have stated under para 55.2
55.2.
very clearly that on the date of the contractor, the contract shall be closed without levying any compensation or damages as provided in other parts of the GCC. Now, if the date of the contractor is not disputed, it cannot be disputed also. It has been informed to them right at the time of his death. And they were also there because the contractor was one of their favored contractors. He has been working under the PWD for a long time. And on his death, they were there. And that was not sufficient. Subsequent thereto, the petitioner had submitted his claim for closure of all the contract works because of the death of the contractor, his father. And as provided under 55.2. Because so far as the other work, that is Hura to Vahai Road, the contentious contract, that though the nominee wanted to continue, but they said, we are not satisfied with your performance, and they did not want to extend or renew the contract with the nominee. So it was left unfinished, but it was not closed as per 55.2. Now subsequently it was retendered without closing it. Now their action have indicated that they have no respect for their own terms and conditions. So in fact, this doctrine of promissory estoppel is to be applied against them. They have made a promise or they have made the understanding to the contractor that they will do under certain conditions, that this will be the terms and condition. But if they are not following it, what will be the result? It will simply result in miscarriage of justice And para 12 is also relevant, Your Lordship. It has been settled by this court that the doctrine of promissory estoppel is applicable against the government also, particularly where it is necessary to prevent fraud or manifest injustice. What will be other than the manifest injustice which has been caused upon the contractor or upon the petitioner? The doctrine, however, cannot be pressed into aid to compel the government or public authority to carry out a representation or promise which is contrary to law, or which was outside the authority or power of the officer of the government or of public authority to make. Now, these are all within their power. It is not against law that this provision has been made. So in that view of the matter, Your Lordship, this law laid down by the Apex Court in this Kasinka Trading and another versus Union of India and another is well applicable. And Lordship, may I take Lordship to the 1996-5 SEC,
1996.
para 6.
Yes. Para 6.
Para 6, yes, Your Lordship. 1995-5 SEC, page 468, para 6. May I read, Your Lordship?
Yes.
We have considered the rival submissions. It is well settled that the doctrine of promissory estoppel represents a principle evolved by equity to avoid injustice, and though commonly named promissory estoppel, it is neither in the realm of contract nor in the realm of estoppel. The basis of this doctrine is the interposition of equity, which has always proved to its form, though stepped in to mitigate the rigor of strict law. It is equally true that the doctrine of promissory estoppel is not limited in its application only to defense, but it can also find a cause of action. This doctrine is applicable against the government in the exercise of its governmental, public, or executive functions, and the doctrine of executive necessity or freedom of future executive action cannot be invoked to defeat applicability of this doctrine. Let me stop here, Lordship. So even here it has been well settled, well laid down that this doctrine of promissory estoppel is applicable not only as a defense but even as a cause of action against the government. And 2014 3 SCC, page 183, para 18. This is in connection with land acquisition, but the law that has been laid down is well applicable because this is a general statement of law. Here at para 18, it has been stated that the 1894 Act, that is Land Acquisition Act, being an expropriatory legislation, has to be strictly followed. The procedure, mode and manner for payment of compensation are prescribed in Part 5. The collector, with regard to the payment of compensation, can only act in the manner so provided. It is settled provision of law, classic statement of Lord Roche in Nazir Ahmad, that where a power is given to do a certain thing in a certain way, the thing must be done in that way or not at all. Other methods of performance are necessarily forbidden. So what has been provided under 55(2) has given the power to the government to close all such contract in a manner provided therein. If they are trying to make other deviations, like after deducting all these excess payment which have been incurred in respect of this particular work, we'll release only this part of the deposits. So that is not what is contemplated under the law which they have created. And may I take a lordship to 2018-10 SCC, para 12. This is also in the same line like that of the promissory estoppel. At para 12, your lordship will see a litigant can take different stands at different times, but cannot take contradictory stands in the same case. A party cannot be permitted to approbate and reprobate in the same facts and take inconsistent shifting stands. The amenability of an inconsistent stand in the same case was considered in Amar Singh versus so-and-so. Quoted. This court wants to make it clear that an action at law is not a game of chess. A litigant who comes to court and invokes its writ jurisdiction must come with clean hands. He cannot prevaricate and take inconsistent positions. A similar view was taken in the case of Joint Action Committee, reported in 2011, 5 SCC 435. Para 12 has been quoted. The doctrine of election is based on the rule of estoppel, a principle that one cannot approbate and reprobate inheres in it. Doctrine of estoppel by election is one of the species of estoppels in pious or equitable estoppel, which is a rule in equity. Taking inconsistent pleas by a party makes its conduct far from satisfactory. Further, the party should not blow hot and cold by taking inconsistent stands and prolong proceedings unnecessarily. So, Lordship, all these rulings which we have relied upon are indicating that the state government, though it has its power and authorities to do certain things in certain manners, but since they have well laid the terms and conditions under a particular circumstance to do in a particular manner, so they cannot prevaricate and say that this will not apply in respect of this particular work and this will apply only in this particular sphere of things. The death of the contractor is certain, it is not denied, and it cannot be denied. He had died, they all know. And now they have taken certain other stands in contradiction to the stand which they have taken at the time of signing the contract agreement. Now, they are supposed to follow their own terms and conditions, as we are also to follow the terms and conditions prescribed by them. So, in that view of the matter, Lordship, my humble prayer is that the respondents are to take action for closure of all the contract works, 11 contract works, in accordance with clause 55.2 of GCC, and to release all the amounts deposited by the petitioner in connection with all those works as security deposit, unbalanced bid security, and the unpaid RA bills, which have not been paid to the petitioner till date. Now that they had released 7 crore something just before filing of the instant writ petition as directed by this honorable court. And now that payment so far has been delayed to a great extent. If they had acted immediately on the death of the contractor, that is on 3/7/2022, they will not be liable for any interest. Now that they have delayed, knowing fully well that they are liable to pay interest under the said provision of law, now after a delay of 3 years, they are liable to pay interest at the same rate. The contractor was also liable to pay interest on taking CC loans, that is the rate of 12.5% from the time of the death of the contractor till it is released to the petitioner. That's it.
Please, Your Lordship. Your Lordship, I'll make my submission in brief because there are persons waiting for me for the mediation since 2 o'clock. Your Lordship, from the whole time that the respected senior has made a submission before Your Lordship, Your Lordship, we can see for clearly that there is a disputed question of facts. So much of disputed question of facts. The first one is with regard to the amount that is there. That is the
No,
first.
but what about the OMAS, whatever was
Yes, my learned
came
friend,
out, yes.
the respected senior is silent on that. But if I take Your Lordship kind attention to my affidavit,
Yes.
page number 40, annexure 2. Now, meanwhile, on the other side, if I may take Your Lordship kind attention to page number 17 of the petition also, so that we can look into the pages together.
Page
17 of
17,
the
yes, page 17.
Here in paragraph number 6, they have tabulated the list of amounts that they have received.
Which they have received, yes.
2/12/2024.
Yes.
But then, Your Lordship, now the petitioner's father, before his demise, was allotted as many as 11 words. So, in annexure 2 of my affidavit in opposition, page number 40, Your Lordship.
Yes, annexure 2. Page 40.
Page 40, 40.
Yes.
Now, here, this is the release of security deposit with respect to Zhongdaepi Moonlight. There are several vouchers. In the next page, in the next, it runs till,
all these are refund of security deposit.
yes, yes.
Till?
So, what I'm trying to impose and repose, it runs till 53. What I'm trying to impose and repose is that this is in addition to the amount that is tabulated herein, in page number 17. So here in page number 17, it was credited into their account on 2/12/2024.
This is exclusive of this amount.
Yes. If you see the amount, that is, even though in page number 17, nothing is written as to what and what amount is credited. But then we can see that the numbers herein, it does not tally some of them.
24, 61. But most of them are tallying. 44,
Yes,
62, 44, 62.
Yes.
62, 11 lakhs.
Yes, what I'm trying to point out is that, Your Lordship, even if it tallies with the same, from the affidavit in opposition, we can see that as to what and what amount is already credited in here in 2024.
Yes.
Now, that is why in my affidavit, the question of interest does not arise. Because because the closure could not be made due to the filing of the investigation that is done by the ACB.
What investigation?
Your Lordship, if I may take Your Lordship kind attention to para number 6 of my affidavit in opposition. Here I have mentioned the fifth line from the bottom. Additionally, foreclosure was delayed on account of the pending registration of ACB inquiry under section 16 initiated so and so. Subsequently, closure of contract was approved of the above mentioned upon the request of his nominee in accordance with so and so, so and so. It was approved. So accordingly, the respondent had released a payable amount calculated in line with the GCC as directed by the Honorable Court.
So you are saying that no penalty has been imposed
Yes, Your Lordship. And then whatever...
and no deductions were made?
Yes, whatever things that we have to pay, we have already paid to the petitioner. So that is the question of disputed question of facts. Now, I'm not saying that the remedy is not extinguished, but then I'm just saying that this is not the appropriate forum to consider the claim of the petitioner at this stage, Your Lordship. And Your Lordship, in paragraph number 8 of my affidavit in opposition, I have stated clearly that the present dispute has arisen primarily due to excess amount claimed by the petitioner and the corresponding excess payment inadvertently released to him in respect of the project work title Construction and Maintenance of Pura Vahai, which was listed at serial number 6 of the Statement of Works.
Your Lordship, if the page number is cited, it will be more appropriate because in para
Page 10.
page
You're reading from para 8, page 10. Your affidavit, isn't it?
Yes, but
para number is not given. Only page number is given from page 18. At the bottom there is para number 3.
No. Their affidavit, page 10,
Page 10.
para 8 is there. That with regard to...
No. Page 10. Okay.
Even though in the original agreement, there is no clause that contains for nomination, to contain official nomination clause. But then on the request of the father of the petitioner, nominees was designated to all his works, and the said request was duly approved and communicated by the department. And with respect to that Pura to Vahai Road, Masom Tuang Arate was designated as the nominee, which is not made a party in the present writ petition also. And Your Lordship, it is further submitted that although the work had progressed to a certain extent under the said constructor, the pace of execution slowed down subsequently. As a result, the work remains incomplete, only with 50.21% physical progress achieved as on date. Therefore, the petitioner submitted that the writ petition stated by the claimant in accordance with the provisions of 43.1 of GCC, the respondent made payments to the execution portion on claims submitted by the contractor. The total amount paid to date is 1409.45 lakhs. And Your Lordship, I'm going to continue reading because it will make more clear.
Yes.
In accordance with the relevant clauses of the contract was paid in advance amount comprising mobilization advance, 73 lakhs, machinery equipments, etc., and thereby totaling 219 lakhs. However, as per 45.1 of the GCC, the entire advance payment is of 219 1980 was fully recovered without interest through proportional deduction from the RA in accordance with 45.3 of the GCC. Now, the respected senior counsel have said that we are blowing hot and cold. It is not that, because my learned friend was reading only the clause that concerns is beneficial to them, that is clause number 52, 53. But then the whole documents, it has to be read as a whole. It cannot be read in part. Now, with the amount that is tabulated in page number 17 of the petition, the several amounts have already been credited as, for example, advance payment for mobilization, etc., etc., which were recovered from the RA. Now, unless we recovered, there will be a huge loss in the government exchequer. Now they are claiming, that is the disputed question of facts. Now they are claiming from the RA, unbalanced payment on the RA. That is the question of facts, which we have recovered. We have to recover it. And the GCC 45.1 clause have permitted this. May I continue reading?
Yes, yes, please.
With regards to performance security, security deposit and unbalanced bid, it is submitted as follows. As per clause 30.1 of instructions to bidders, ITB under standard bidding document for PMGSY, the successful bidder contractor shall provide the employer a total performance security of 5% of the contract price for a period of 5 years and for the duration of completion of the construction work, along with additional security for unbalanced bids in accordance with 26.3 of the ITB and clause 46 part 1 GCC. Further, clause 30.2 of the ITB provides that the performance security of, that is 5% plus half 2.5% to be delivered to the successful bidder after receipt of letter of acceptance shall be either in the form of bank guarantee or fixed deposit receipt in the name of the employer issued by a scheduled commercial bank. Accordingly, the contractor submitted performance security amounting to 2.5 of the contract price to the employer after the issuance of letter of acceptance, and the same is currently held in custody of the CEO Mirda Aizol. So that is why it is being held. 5 years, Your Lordship. Employer shall retain security deposit of 5% and performance security of 2.5% from each payment due to the contractor until completion of the entire construction work. Accordingly, deductions was made from each RA bill towards security deposit and performance security as per the above clause. The cumulative deductions retained in the ENCPWD amounts to 71,21,522 towards security deposit and 35,60,711 rupees towards performance security. It is also pertinent to note that since the contract was awarded at 9.52% above the estimated above put to tender, the requirement for additional security for unbalanced bid does not arise. Consequently, no amount was required to be submitted by the contractor on this account.
So this performance security and security deposit doesn't have to be refunded back?
After completion of 5 years.
After completion of 5 years?
Yes, Your Lordship. If we come back to page number 12, the last paragraph. This is as regards to the ITB, instructions to bidders. Performance security of 5% of the contract price for a period of 5 years and for duration of completion of the construction
Where is that?
work.
Where is that?
Page number 12. Last paragraph.
Oh, okay.
So in this, according to this clause, in page number 13, last paragraph, deductions were made from each RAB towards security deposit 5%, and performance security, and the total which I have just pointed out. And Your Lordship, in addition to that, in page number 14, last paragraph, in line with the government procedures for execution of work contracts, mandatory deductions of goods and service tax, that is GST, at 2% and labor cess at 1% were made from each RA bill, including deductions towards security deposit, performance, advance payment, GST, and labor cess. The total deductions amounted to so and so. Consequently, the net payment released to the contractors to so and so. The cumulative RA bill payment made to the contractor thus far is so and so, which constitute 90.12% of the contract price of 15 crore 63 lakhs 92,759. And there was disparity and slow physical progress of work, which we have already pointed out, and spot verification was made. And in page number 16, Your Lordship, page number 16, under the clause spot verification and excess payment. After the spot verification, it was found that excess payment of 762 lakhs 44 lakhs has been made to the contractor. The discrepancy arose as the actual length of payment executed inside was only 3.085 kilometers, whereas payment has already been made for 15.000 kilometers.
Petitioner was also present during this spot verification.
After that, Your Lordship, after that, in the petitioner presence, I don't know, he was not present, Your Lordship. Only the SDO Tuipang, JE and manager. One manager was there. His manager was there. In page number 60.
The question did not arise because the contractor had died and he was not allowed to continue with the work even by the nominee. So whatever work that has been or verification that has been taken in the absence of the contractor during his lifetime or after his death, at least if his nominee was allowed to continue, then that's a different matter. In the absence of the nominee, that is Mr. Nalson Kluanga, all such verifications were said to be carried out.
Your Lordship, in page number 60 and Extra 8, the members present, including the engineer-in-chief, will be there. 3 persons. Manager is there. And there is also several meetings that was held between the petitioners as well as the state respondents, which is not fruitful, which was not fruitful. So our main contention is that, Your Lordship, I'll be relying really on my affidavit in opposition. Our main contention is that in reading the ITV as well as the GCC as a whole, there is a provision or a clause that has allowed us to make the deduction and to retain the amount, whatever. And the payment which we have made in compliance with this honorable court order in the previous writ petition, after careful consideration, the amount was duly credited in the year 2024, which the petitioner are now disputing. But then we are saying that we do not have any amounts to pay at this stage. So there is clearly a disputed question of facts, Your Lordship. Presuming but not admitting that there is no question of facts, Your Lordship, but then unless evidence is left by, in this case, how we will ascertain, since we are not an expert, how can we ascertain that the amount tabulated by us or the amount tabulated by
them
is correct? We cannot do because we are not expert in this. In this regard, may I rely on one judgment, Your Lordship? This is basically about a question of facts only.
Okay.
It's 2025 SCC online SC 447. I'll go to paragraph number 48. Page.
Yes.
Okay.
Paragraph 48.
Normally, the disputed question of facts are not investigated or adjudicated by the court while exercising power under Article 226 of the Constitution of India, but mere existence of disputed question of facts by itself does not take away the jurisdiction of this writ court in granting appropriate relief to the petitioner. In a case where a court is satisfied, like the one in hand, that the facts are disputed by the state merely to create a ground of rejection of the writ petition on the ground of disputed question of facts, it is the duty of the writ court to reject such contention and to investigate the disputed question of facts and report its finding if a particular fact of the case, like the one at hand, was required in the interest of justice. So, if we are saying that there's a disputed question of facts, it has to be recorded in writing that there is no disputancy of facts, dispute of facts. And jumping to paragraph number 53, Your Lordship. Thus, it would all depend on the nature of the question of facts. In other words, what is exactly that the writ court needs to determine as to arrive at the right decision. If the issue that revolves around the entire debate is one relating to actual taking over of the physical possession of that so and so. Now, this is not applicable in the 2-3 lines. The next sentence is not applicable. It would all depend on the nature of the question of facts. Now, I'm saying that the nature, that the one that we have is one such that that needs evidence that to be led by an expertise in this case, along with some documents, supporting documents, Your Lordship. Now, from this table, how will we ascertain what is correct and what is not correct and what is the correct form of tabulation? So my main contention is that documents, we do not blow hot and cold. On reading the ITB and GCC together, it should not be read in part, but should be read in whole. And then all the accounts that is already credited or the amount that is tabulated should be clearly justified, because there are several deductions as per law that has to be made, and several payments is already made, and this will have a huge effect on the state exchequer. Now, their entitlement we cannot deny. The entitlement of the petitioner we cannot deny. But then as far as the state respondents is concerned, we do not owe them anything at this stage, Your Lordship. So, Your Lordship, with that...
So, what you're trying to say is, as per the GCC, you have made the deductions.
Yes.
And these are not by way of levying any damages or compensation,
yes.
as per 55(2).
Correct.
That is your
Correct,
contention.
correct. It should be read as a whole, not in part. And Your Lordship, with that, I will not stay from the respected seniors counsel reply if I may take your leave.
Okay, you can leave. Yes.
Lordship, since my learned friend is in a hurry, it appears that there are certain other things which are more important than the proceedings of this honorable court. Anyway, I'd like to rebut some of the submissions, like the spot verification,
Yes.
as per page 16 of the affidavit in opposition. First para. What has been stated is that Mr. Engineer Laurin Kimanamte, Chief Engineer, Planning, was deputed to carry out verification via letter number so and so, dated 14/11/2022. 14/11/2022. That was some few months after the date of the contractor. And before
that spot verification.
Yes. Before any appointment or renewal of the contract has been made in respect of any of the nominee or the petitioner. The petitioner was not willing to continue, and the nominee, in respect of that particular work, Mr. Malson Pluanga, though he had volunteered to continue, but his candidature was not accepted. And under the given circumstance, spot verification was conducted in the absence of any representative from the contractor or the petitioner. So whatever finding that might have been made against the contractor or in the process of the conduct of or execution of the contract cannot be accepted by the petitioner, because he was not participating in the spot verification. That was
spot verification.
That was spot verification
16
conducted.
to 16 to 19 November.
Yes. Conducted behind the back of the petitioner and in the absence of any representative. And so far as the stand of the respondents that the GCC and ITB needs to be read in whole. We have read it in whole, but there are certain things which are applicable, which are not applicable. Just because it has to be read in whole does not mean that clause 53, that is payment upon termination, clause 53, which has been relied upon for the purpose of deduction, whether that is applicable in respect of the contractor, the deceased contractor. Now, this is a clause which is applicable to the contractor during the subsistence of the contract and before the death of the contractor. The question of termination will arise only when the contract was was alive. The contract was no longer in existence because the contractor had died. There are certain things, like what is provided here is that under clause 53.1, subclause 1, if the contract is terminated because of a fundamental breach of contract by the contractor, the engineer shall issue a certificate for the value of the work done, less liquidated damages, less advance payment received, up to the date of issue of the certificate, and less the percentage to apply to the value of work not completed, as indicated in the contract data. If the total amount due to the employer exceeds any payment due to the contractor, difference shall be recovered from the security deposit and performance security. If any amount is still left unrecovered, it will be a debt payable to the employer from state PMGSY works and the state government works, including state public sector works executed by the contractor. All these actions are supposed to be taken during the lifetime of the contractor and during the subsistence of the contract. The question of termination will arise only when the contract is alive. On the death of the contractor is no more there.
Okay, so regarding this new NIT with regard to maintenance of Pura to Vahai Road,
Yes.
do you have any information as to whether they have started the work?
They must have.
Because this is of 25th November 2024.
On 20th January 2025, work was allotted to Sri Balaji Construction.
Okay.
On 20th January 2025.
20th January 2025.
It was allotted to Sri Balaji Construction Company.
Yes.
And the respondents have been harping that they have made excess payment of the amount. There is no provision of making excess payment other than what is provided under a particular
They're relying on the spot verification report.
Yes.
Yes, they are saying that the actual length of payment at the site, the actual length of the pavement at the site was only 3.085 kilometers, whereas payment had already been made for 15 kilometers. That is their statement.
Yes, they have stated that, but that cannot be relied upon for the purpose of determining whether there's excess payment or not, because whatever measurement that was made in the presence of the contractor or his nominee was taken before making the RA bills, running account bills 1 to 9. And at that point of time, all measurements were made, and the actual measurements which were recorded in the by the respondents and uploaded in the OMAS. That is the only reliable information or data which is to be relied upon. Other verification report which has been taken behind the back of the petitioner cannot be acted upon. And there is no provision for making any excess payment Your Lordship, we have made a statement to that effect. I'm just looking for the actual provision. I'd like to state that there's no excess 45, clause 45.1. 45.1. is regarding advance payment. May I take a lordship to page 71 of the writ petition.
Advance payment.
45.1, yes. This is regarding advance payment. On the request of the contractor, the employer will make the following advance payment to the contractor against submission by the contractor of an unconditional bank guarantee from a scheduled commercial bank acceptable to the employer in amounts equal to 110% of the amount of the advance payment being requested. A. Mobilization advance up to 5% of the initial contract price, excluding the contract price for routine maintenance. B. Equipment advance up to 90% of the cost of the new equipment brought to the site, subject to a maximum of 10% of the initial contract price, excluding the contract price for routine maintenance. These are the two instances for making of advance payment. Other than this, there is no provision under GCC for making of any advance payment, much less the excess payment. The question of excess payment cannot arise at all. The work that has been executed is taken into consideration by making correct measurement, entering that measurement into the measurement book, recording it in the computer, and uploading it in the OMAS. And on that basis only, the bill has been released to the contractor at a belated stage. That too at a belated stage. While the provision of this GCC has said that from the date the engineer signs or makes a certificate to that effect, within 15 days, the bill shall be released. But that was not followed in many of the cases. Within 15 days of the billing, it was never released. And here the stand of the respondents is that we have paid excess, we have made excess payment in respect of that particular work, which is apparent on the basis of the verification conducted by the chief engineer after the date of the contractor. Whether all those things are to be relied upon. My humble submission is that
we
it
will
cannot
look
be.
into that also, that you were not present during the spot verification.
Yes.
Okay.
And when the law has clearly stated that without levying any damages or compensation as provided for in clauses 44 and 53. Still, they're levying those compensation and damages, making deductions.
They have said that it's not damages or compensation, but it is the excess payment. And then they said the rest is the security,
they said it is an excess
security
payment.
deposit.
Excess payment.
Which can be released only after 5 years. That's what they said.
No, that even 5 years is the defect liability period. After completion of the work, those works are to be continued to be maintained by the contractor. But under the given circumstance, when the contractor had already died, that defect liability is taken over in respect of the person taking responsibility. That will be taken over by the person who has been appointed as the continuing contractor. That defect liability period also. The unfinished work will also be taken over by the person who will be appointed.
Who continues the work.
To continue the work.
Okay.
And that liability, defect liability is also, the liability is put upon the new contractor who is appointed. And even now, Balaji Construction Company, they have been appointed and they will take over, they will take care of whatever liability that has been there in respect of the earlier contractor. Because they cannot, as they are very sure, they are not in a position to impose any such liability upon a dead person. So that defect liability period of 5 years is not applicable in respect of a dead person under clause 55.2. And this being the situation, Your Lordship, the manner in which the matter has been conducted, and we do not know what is there with the officers, the engineers of the department, whether they have done something wrong or not. That is not a lookout. We have been given the allotment of the work. We have done all that we could, and after that, the contract needs to be closed as per 55.
Okay.
And during his lifetime, all that liability that needs to be fixed upon the contractor will have to be fixed, not after his death.
Merci. Yes. Heard Learned Senior Counsel, Mr. Sergeant, assisted by. I also heard Miss Emily. Was it no? Mary County Government Advocate. Judgment reserved.